You're watching This Social TV from the Social Collectives. Welcome to Small Talks with the Social Collectives. Today, our legal panel will help small businesses grow with clarity and protection. This live stream is brought to you by McCabe's Printing Group, Artisan Plumbing, and D Hill Financial, and Jeff in High Def. Now, here's your moderator, Lisa Ann Adams.
Hello, thank you so much for being here today at the International Country Club with the Offit Kurman legal team. So thank you for being here, guys. We really appreciate your time. And thank you for everyone that showed up. So I would like to begin this discussion by introducing my friend, Mark Shaffer. Mark Shaffer is an extraordinary man. One of the things that I find extremely interesting about Mark and admirable is that Mark is a lifelong U.S. Marine Corps man. And he is actually serving currently in the reserve status. I guess Saturday you were jumping out of an airplane?
Yes.
So he was jumping out of an airplane with a group of veterans, and they are a nonprofit that I'll let you talk about if you want. But I just wanted to thank you so much. Mark is also one of the best trial litigators in the country. So we are extremely fortunate to have him here to give us his legal advice for free. Last time you're going to hear that next to an attorney's name. So anyway, so thank you so much, Mark. I'll let you take it from here.
Thank you, Lisa, for having us, inviting us to. Can you hear me now? Thank you, Lisa, and everyone for being here today and for inviting us to speak to the collective. I'll just talk briefly about my practice and let Russell and Courtney, who are joining me today, and I thank them for their time today as well. But I have a national trial practice doing construction litigation. Microphone needs to be closer. Is that better, David? I have a national trial practice doing construction litigation and land use litigation, doing everything from development disputes, easement disputes, to a wide range of construction claims. I also do some corporate disputes as well. Russell, you want to introduce yourself?
Morning, everyone. My name is Russell Berger. I'm a business and labor and employment attorney at Offit Kurman, where my practice focuses on representing small and medium-sized businesses, and with respect to largely business and employment issues. So that means keeping employers out of trouble, putting the right policies in place, giving the right advice, going through counseling to make sure that we're setting things up in the right way. And even then, if you have enough employees, you're going to run into problems at times, and I'm there to help put out those fires as well.
And good morning, everyone. My name is Courtney Alvarez. I am counsel in Offit Kurman's insurance recovery practice. And what I mean by our insurance recovery practice is that we represent policyholders exclusively in pursuing claims against their insurance companies. I also do some commercial litigation and landlord-tenant work, but I'm excited to be here with you all today to go over some tips and tricks that you should consider implementing in your businesses to maximize your insurance coverage.
Awesome. I'm going to talk first, but before I do, two things I want to comment about Russell and Courtney. One, Russell, he didn't say this, he also advises our firm. We have 250 plus lawyers and probably twice as many staff on all their employment and labor issues. And then Courtney works with me a lot on a lot of the construction defect claims, helping owners and contractors navigate through those insurance issues. So without any further ado, I'm going to speak first, and I'm going to talk about really three issues. I might skip over the second depending on time because there's a lot to discuss today. If you have questions, please let us know. But the three areas I want to talk about are, one, important construction contract provisions. And why are they important? The provisions I want to focus on today are the provisions that come up most often in disputes between owners and contractors. And there may be times where I may be more focused on an owner or contractor side. Forgive me if I do that. I know we have both owners and contractors. If you want me to focus on one versus the other, just let me know and I'll do my best to field your questions. I'm going to try to spend some time talking about some best practices to avoid disputes when they do arise. And then lastly, I want to talk briefly about some commercial leasing issues that we're seeing, especially coming out of the pandemic and issues that are still arising today. So construction contracts. The one point I want you to take away today is if you have a construction project, whether you're the owner or the contractor and that's your business, I want you to consider having someone look at your contract if you have a contract. If you've never done it before, I want to encourage you, do not go online and find a contract and make it your own. I really want to strongly encourage you to speak out to a construction professional that has done this more than once, that has seen these type of pitfalls, that can help you navigate these issues going forward, and have someone help you prepare a good construction contract. You would be surprised, it's not as expensive as you might think. And the protection that that's going to provide you in the future may save you anywhere from tens of thousands to hundreds of thousands of dollars. Just by way of background, I think the smallest construction dispute I've ever handled was probably around $35,000, and the largest was about $70 million. So you can really have some issues come up in a construction project without a good construction contract documents. And the first slide just kind of bulletized some good project documents. What they're going to capture is, number one, the party's intent. That really is key, and I was talking to someone earlier, I was talking to David, and we were talking about how important it is for both the owner and the contractor to manage each other's expectations on what they're getting, what they're paying for, and what they're receiving. Because a lot of times that's where the dispute begins. An owner, especially an owner who hasn't done this before, and if you are that owner, this is really important for you. You may think that what you're getting is something different than what the industry standard is. So it's really important to have a good contract that spells out what your expectations are. Obviously, we want to identify the scope of work and the price for that work, and that's important, and that encompasses everything, not just the contract itself, but if you have drawings and design documents. So you really want to invest the time to get good drawings and good design documents, because if those are incomplete or if they're not clear, you're going to run into issues down the road when the contractor gets on site, realizing that there's questions that have not been answered, that were not incorporated into the bid, that are going to result in an increase in price down the road. Anticipate potential problems. What do you do if you have a dispute? Do you just go to court, or do you have some sort of dispute resolution process? So you want to think about that. And a good contract is going to reduce the risk for claims and litigation, and we're going to talk about some of those issues as well. And then lastly, a good contract, and this is really important, you want to always include a form selection clause. And what is that? That's going to say where the dispute is going to be handled. Most of us, I would assume everyone here, is probably Virginia-based. The last thing you want to do is to have a contract where you find out that you're being sued in New York or Pennsylvania or another jurisdiction where they're trying to argue that that jurisdiction's law should apply, because that could have potentially significant impacts on your rights under the contract documents. So some of the key provisions, just to review today. First one is a warranty provision, that the work will be good and workmanlike. What does that mean? Good and workmanlike, if I talk to a contractor, it's going to mean one thing. He's typically, or she typically, is going to say, it means that it's fit for the intended use. If it's a house, you can live in it. If it's a restaurant, you can use it for a restaurant. If I talk to an owner, they're going to say, it's perfect. That's what good and workmanlike is. And that really comes down to the details of this term. So you really want to make sure you understand and manage that expectation, and this is probably one of the most important terms to do that. Also including your contract, and this may seem like common sense, but a provision that says if there's defective work, the contractor doesn't get paid to correct that defective work. Where does that come up most often? There's different ways that you can negotiate a contract price. The most common is just a lump sum. You get someone to bid and say, I'm going to do it for $2 million. Another way to do it, which is potentially a way to save money, would be a cost plus, where you are billed for the cost plus some management fees and overhead costs on top of that. If that contractor is not a good contractor, or maybe if you're not managing the project, or the contractor's not managing the project, sometimes you might run into is where there's defects, and they'll charge you to fix those defects. You want to include that provision. Another one, and this is really important and one that's subject to a lot of interpretation, is you want to have a provision in there to supervise your work. And this is one that comes up a lot, and honestly, a lot of the disputes that we have when it comes down to defects or failure to complete the work on time boils down to a supervision issue. Most owners, or even when there's cases where there's just a misunderstanding between the owner and the contractor. And what do I mean by that? If I talk to an owner and they have a provision where their contractor is supposed to supervise the work, most owners will assume that that contractor, or the main contractor, the owner of the business, is going to be out there on a daily basis. That's not true. You can ask for it, and you can require that. If you do, it'll probably cost more. But there's a lot of ways to supervise a project. They could supervise. A lot of them just call in on a weekly basis, or a daily basis, or a bi-daily basis. But if you want that more detailed supervision, and there's projects where that's important. For example, if you're going to build a one-of-a-kind restaurant that's going to be a unique restaurant experience with all these high-end details, that's probably a project where you want to spell out greater supervision requirements. But just think about that and including that language and negotiating that. And I'm sorry, am I going too fast? Because I have a lot of information and I talk a lot.
This is great.
And Lisa, you can
Okay.
elbow me. Perfect. Some other protections to afford. I think, are we going to give them the PowerPoint after this?
Whatever you want.
Yeah. Please, we'll give you the power. Are you okay, Russell?
Yeah, sure.
We'll give you the PowerPoint so you can review this. Another provision to protect you are mechanics liens. I don't know, for those that don't know what a mechanics lien is, it's used by subcontractors and contractors if there's a pay dispute. As an owner, you may think, well, I don't want to pay you because I don't think you did good work. We'll go to court. One of the things, remedies that a contractor or subcontractor has is they can put a lien on your project, whether it's your house or your restaurant or whatever it is, your store. That can be a powerful remedy for the contractor for any number of reasons. It could impact your mortgage. It could impact your ability to get a loan or refinance. It could do a lot of things. So one thing to consider if you're the owner is negotiating that lien is waived. And importantly, one of the reasons why you want to pick a good forum like Virginia is because in some jurisdictions like New York, you can't waive a right to file mechanics lien. There's statutes out there that say any type of waiver provision of mechanics lien is unenforceable. And of course, if you're a contractor, you really want to strongly consider, do you want to give up that right? Because that is a powerful remedy. Another thing you can do is you can require a bond, a construction bond. And what is a bond? Typically, it's a performance bond. So if you have a dispute with your contractor, or worst case, your contractor goes out of business, it happens, right? We're coming into a recession, or we are in a recession, depending who you're talking to. That could happen. And if you have a big enough project that's underway, you don't want to have your contractor walk off and leaving you stuck with an incomplete $5 or $10 million project. So consider requiring that bond requirement. It will result in a little bit extra cost on the bid, but it shouldn't be that much to where you should forego it. And then I've already talked about this, the choice of law and forum selection clause. Every contract should have that. If you're in this room and you operate in Virginia, I would strongly suggest picking Virginia. Virginia's pretty good with its contract law and enforcing contract provisions. But if you have a reason to do it somewhere else because you want to be in New York or Delaware, you can talk to your lawyer about the pros and cons of that. But it's best to know going into the contract where, if there's a dispute, that you're going to resolve
What
it.
was the name of that thing everybody has to have?
Choice of law and forum selection clause. Yep.
Can I just ask a quick question?
Yeah, please.
So, you just brought up a point, which are different locations. And so, as small business owners, we always hear, yeah, my business is domiciled in Delaware or Pennsylvania. Can you just sort of give us a couple of minute response on if we're thinking about setting up a new business, are there reasons why we may think about that outside of business?
So these are two different things. So let me talk about the contract first. So the contract is your agreement between you, whether you're the owner and the contractor, right? That's going to govern your rights and obligations. And what you're doing with that is you are selecting the forum, in this case, for example, Virginia, where if there's a dispute over your contractual rights and obligations, where it will be decided, and the law that it will be decided under. So what I would recommend, if you're in Virginia and you're a Virginia business, you want your contract to be here, so you don't have to go up to Minnesota or New York or Texas or wherever it is. And you probably have had some sort of service agreement at some point with a phone company or someone to where they have some weird form, right? You have to go to Seattle for your disputes or arbitrate it in Switzerland. That's a contractual form selection clause. David, your question deals with where do you want to form your business? Do you want to form your... No, that's fine. That's fine. And there's a lot of considerations for that too. A lot of businesses decide to use Delaware law, and the reason why they tend to go with Delaware law is because Delaware law is very favorable for a business owner, specifically if you are a corporation or an LLC, a limited liability company, because what Delaware law typically does is Delaware law gives broad protection of something called a business judgment rule. If you are a closely held business where it's just you and your spouse, this really doesn't matter much unless you plan on getting a divorce. But if if you are a bigger business where you're going to have a lot of members, maybe what you do is you set up your business and you have cousins, you have aunts and uncles, or maybe you just have unrelated investors that are all members of your LLC, or maybe they've invested in your company and you've issued stock to them. It's important to consider the form that you're going to form your business under. Again, Delaware is an example you brought up, because they tend to give a lot of discretion to the directors in the case of a corporation and officers, or in the case of a LLC, the managing members, in how they do their day-to-day business. And that discretion is under the business judgment rules. So as long as you're doing things that are typically in the best interest of the company and you can justify it, Delaware has pretty favorable laws for that. And there's other things, and this could be a whole separate session, and we're happy to come back and talk about that. Where you have to be mindful of, if you are going to grow your business and have investors or other members that you owe fiduciary duties to, it will change your business, because that happens, because you go from being a small business to where it's just you and maybe your spouse or a close friend, and you start growing. It's easy for you to decide how much money you're going to take out of the business, and maybe you're going to have business expenses, whether it's a business car, whether you're going to do marketing and fly to California and speak here. Those things can get scrutinized more if your business grows and you want to have that form. For example, Delaware, that's going to protect you, but no form is going to protect you from extreme self-dealing or breach of those fiduciary duties. Does that answer your question?
Extreme self-dealing is where you overuse your budget. So like, you're going to fly to California, go see a concert, have a really nice dinner, get a limo, right?
Not necessarily, but or maybe you're saying it. Maybe you're saying it the same way. But yeah, if you decide to use your company's money, you have investors, right, who want distributions, and if there's no distributions because you're flying your whole family to California, I think is what you were saying, and you're going to a concert, yes, that would be self-dealing. Or you hire your nephew who has no experience in your business and you pay them a six-figure salary just to get them going, right? That would be an example. Thank you. Yep. All right, any other questions? Yes?
So you talked about LLCs and corporations. Maybe this is too far off of your topic here, but when is a corporation more important than going to an LLC?
That could be a whole hour-long discussion. It has a number of issues related to how you're going to run it, tax consequences, and really what the purpose of your company is and how you plan to do it. So there's a lot of factors that we if you want to talk afterwards, I'll see if I can give you more details.
Okay.
All right, any others? All right, I picked the wrong topic.
LLC one is a big one.
Yeah. Another key provision, and both these are interrelated, time to complete the work and substantial completion. A lot of times, especially if you're doing a commercial property, you want to tie in that time to complete the work to a specific date, because if you're opening a restaurant, for an example, right, there's going to be a lot of things that are going to tie into that. You have marketing that you want to tie into that, right? You want to announce that you have your grand opening. You need to hire staff. You need to load up with supplies. Everything you need to get that business going, and you just can't do that on the fly, right? You can't say, oh, we're opening next week, great, let me make that happen. You need months and months and months and months advance. So you want to identify that and make that date very, very clear. And the two most common ways to do it is you give them so many days from of a notice to proceed. So the day they start work, they might have 6 months, 180 days. Or another one is you pick a date certain. You will complete this project by October 1st, 2022. And then what does it mean to be complete? The term of art up there, substantial completion, and this is another term, unless you really draft it well, could be subject to a lot of different meanings. One meaning of substantial completion, and I see this, the project will be substantially complete by October 1st, and they don't define it. Well, now, if I'm the contractor, substantially complete to me means that it's complete and ready to be used, and if I can get a certificate of occupancy, we're good. What you don't know about a certificate of occupancy is there can be a lot of punch list work. You'll have your HVAC, your plumbing, your electrical, your water, that'll be running, but there could be a lot of what may not be very minor punch list work that needs to be completed. So you really want to define that. A suggested minimum definition would be that the work progresses to the point to where it's complete according to the contract documents without deviations, except for minor punch list items. I could argue for days and days and days what minor punch list is. I'll have a different interpretation than that. So you can really build and expand upon this definition. I encourage you to do that. One way to deal with that in your contract, if you're an owner, and this happens a lot, is you'll hire a project manager, and this will be someone in the construction industry that's familiar with this, and there'll be a third party, and that third party will decide whether or not substantial completion has been achieved. And the way you'll inform the parties that substantial completion has been achieved is you can require the issuance of a certificate of substantial completion, right? And so just something to consider in that. The next slide deals with flow-down clauses. A flow-down clause is exactly what it says. So you have this great contract with your contractor. Now, what does that contractor do? They don't complete all the work. They're going to hire subs, right? There's going to be electrical subs. There's going to be, if you need glass, there might be a safety glass sub. There's going to be plumbing, HVAC. All those subs are coming in. What do their contracts say? So you want to require in your contract with your contractor that there's a flow-down clause that makes sure that all the subcontractors are bound to the same obligations as your contractor. And that's just going to provide for consistency in payment, performance, default, termination, all those things that are important for you, that you have these nice protected rights. You want to make sure that that is incorporated into the contract, okay? I feel like I'm going so fast.
Does anybody have any questions?
Yes.
So for the substantial completion,
Mhm.
for this substantial completion clause in the contract, would it be okay to get specific, or can that, like, for example, with flooring industry, if I would say something along the lines of substantial complete means everything except trims and changes, because sometimes paint will be held hostage for
Right.
$30 piece of order.
Right. So yes, so both sides should be specific in their expectations when negotiating that term, because to your point, David, if you do floors all the time, you understand the sequence, you understand what is industry standard. Many owners may not, right? Some do, right? But there's also others that don't. So the best way to avoid that dispute is to be as specific as you can. And now, on the flip side, if the owner gets too specific, right, then there's a consequence to that. And that consequence is you might get overinflated bids, right? So there's a trade-off there. I'm sorry, did you have a question?
Yes. So, about the flow down clause. I am a contractor, so since I have subcontractors to do contract, can I make a contract or this subcontractor to have the same obligation on me for the work by putting my contract in?
So
Again, just to repeat the question is, if I am a contractor, and I have subcontractors, can I have the same requirements as my subcontractor? Did I repeat the question correctly?
Yes, thank you.
yes, I mean, and you should, because it allows for consistency, and that's the whole purpose of the flow-down provision. Because as an owner, I have expectations that I want the project completed a certain way. I want a certain level of supervision. I want a certain warranty of work. I want, and we're going to talk about change orders in a little bit. I want the same change order process done. And so that's typically what you do, and you can do that by incorporating the contract. So you can have a clause in your contract that between the contractor and subcontractor that says the subcontractor agrees to follow all the payment clauses, and you spell them out. That's in the contract between the owner and the contractor, and make that as an attachment, or you can just mirror it. I mean, there's a lot of different ways to do it, but yes.
And so, this brings me to another question.
Okay.
So how may this subcontractor, so here's what I have to do with subcontractor, but let's say I have someone that say, no, I don't wanna,
They don't want to agree to it?
yeah, like, has the obligation.
They don't want to agree to, then, well, if you're the contractor and your contract with the owner says you have to have a flow-down clause, I would advise you that if that subcontractor refuses to do it, not to use that subcontractor. I mean, you just, because potentially, if you have a dispute down the road, the owner is going to use your failure to include a flow-down clause against you and say, you're in breach, you didn't do this, and you just want to avoid that dispute. Yep, thank you. Any other questions? All right. these are obvious points to consider. Outlier bids, the one point I want to make about that is you're tempted to go with the lowest bidder, right? But the lowest bidder is not always the best. Sometimes they are. Sometimes they are. You can get a great contractor, they come in and they're just efficient and they do it great. But sometimes they're not. And how do you know, right? The point I want you to take away is when contractors do a bid, and it depends on the project, a small kitchen project, they're not going to do this, right? But a larger project, if they were building this country club, you can have them do a complete takedown by sequence of what they're doing and show you how they're bidding each part of that. And if you, as an owner, are concerned and say, I don't know, I don't build country clubs, you get yourself a project manager that does, and they can help you in that bidding process, look at the backup and the breakdown and say that this bid is correct or it's probably low. And that's important because if you take a bid that's going to be low, you're guaranteed to face change orders. Because at the end of the day, any business out there is not going to lose money on a project if they can help it. And the easiest way to recoup that money on a low bid is to sometimes, unfortunately, create reasons to come up with change orders. We're going to talk about that in a minute. Then I talked earlier about bond requirements, performance bonds. Again, something really strong to consider. A good contractor shouldn't have a problem with obtaining a performance bond. In most cases, if they do, was that time for? 10:40. 10:40? Oh, wow. Are you guys good staying a little over?
Yeah.
A little bit? I'll
I can
jump
cut
forward.
mine a little short
Okay.
too.
All right. Change orders, the big point I want to make about change orders is have a detailed change order provision. All right. And the importance of the change order is if they're going to make a change to the contract price or the scope of work, what you really ought to strongly consider is making sure that you have a detailed change order provision that makes it clear that they will have a written change order before they do any extra work, and that they will have a written change order signed by both parties that identifies what the extra work is, what the extra time to complete that work is. And I would also strongly encourage including in that change order provision that there's a release of any other claims that they might have. And the reason why that's important is because sometimes you'll resolve change order number one thinking we're done, right? I paid you extra money. And then as soon as you sign it, oh, here's change order number two. I forgot about this. And it really becomes a death by 1,000 paper cuts. The other 2 points I want to make about that is draft a form change order document, and that's the only change order form that's acceptable. Because otherwise, you'll get email correspondence back and forth. I'd like to do extra work. Do you approve? And while that can be a way to approve a change order, that can be very sloppy, and it can lead to additional disagreements. And then what you'll find out is other emails that you had between the parties are being interpreted as authorizing additional change orders that may lead to a massive amount of change orders at the end of the project that will shock you. So just be aware of that. Best way to avoid these disputes is just make sure at the beginning of the project that your team, if you're the owner, understands the change order process. If you're the contractor, that the contractors as subs understand this is the change order process. If you don't follow it, have a provision in your contract that says failure to follow the change order process waives any claims for extra payment, okay? And that's just an example change order provision that we provided in the slide deck. Damages and delays. Delays are money, okay? There can be numerous reasons that you can have delays on a project. And there's different types of delays. There's excusable and non-excusable. An excusable delay is one that's not your fault, right? Things that you think about, acts of God, right? COVID, right? You get shut down because of COVID, you can't work, things like that. Non-excusable delays would be the contractor doesn't manage the project properly and falls behind, or when the owner can be responsible too. The owner is giving requests for information. I need to know how to, the design documents are not clear to me. I need to know if you want to have this type of piping or a different type of piping. If you don't respond in time, you can actually cause delays, and as the owner, you can actually be required to pay for extra time because that contractor is stuck on the project an additional 30 days. That's 30 days that contractor isn't working on other projects, and they would have a basis to submit a claim for extra time and extra money. A point I want to make about consequential damages in your contract provisions, just something to consider to help with your bids. Consequential damages are a way for an owner, if there's delays typically, to recover lost profits. So if they don't complete the work on time, you would want to be compensated for lost profits. I was supposed to be open on October 1. I didn't open until December 1. I had all these things lined up. Consider waiving that. And the reason why you want to waive it is because that is a big risk to the contractor, because they don't know what your damages might be. Or you could cap it, but just something to consider. And a thing that I would suggest replacing it with is a liquidated damages provision, which is a preset amount that you identify every day of delay. You're going to pay me $500, $1,000. If it's a big enough business, potentially $5,000. The key is you don't want to make this a penalty. So think about your business, think about what might be related to the type of profits you would expect to receive, and make it based somewhat on that. If you come in there, I don't know, if you're selling dog toys, I don't think you're probably going to make $15,000 in profits a day. So if you were to have $15,000 per day, the court would probably find it's unenforceable, but just something to consider. Force majeure clause. We talked about that briefly. The big point I want to make is a lot of people paid zero attention to this for years because it just never came up, right? The big thing about a force majeure clause is it gives you an excuse not to perform. And the important part I want to put in that is, one, make sure you have a notice provision that requires them, if they are going to invoke the force majeure and say an event happened, a weather storm, pandemic, government shutdown, that they give you notice within so many days of the onset of the event. That protects you from, at the end of the project, them coming up with a massive delay claim saying that they were delayed or they're excused. And then the last bullet point is key, and most people have done that, but if you're using an older contract, update your force majeure clause to include pandemics, government shutdowns, and things related to that, to other excuses. Things you might want to think about now also, potentially, is supply chain interruption. All right, inability to get materials, right? I have a lot of clients who, every time I talk to them, they're on the phone trying to figure out how to get their products into the country when they need things. So just something to consider. Different site conditions, just briefly, you want to think about how to address that in your contract. What if the contractor gets out there, and an easy one that comes up a lot are soil conditions. They anticipate it being easy soil to excavate, and it turns out there's a bunch of rock or clay. But also inside of commercial spaces, if you're buying inside of a shopping center, you think you're going to have connections that are going to work for your business, whether they're electrical, plumbing, HVAC. It may turn out that they're not. That would be a different site condition. So you want to spell out how you handle that. How are you going to compensate the contractor, and what the process is. This is one just to think about. With an escalation clause, this goes back to what we're dealing with the pandemic and the ripple effects of the pandemic. A lot of times contractors bid on a project months in advance before it starts, right? Today, that's risky because your bid today is probably good for about 30 days, right? It used to be you bid a year out and you're pretty good, you build a little bit of buffer, but people never anticipated that the price of lumber would go up 500% and other things. So think about incorporating an escalation clause that protects you if you're the contractor by identifying a preset formula to determine how you're going to handle increase in materials from the time that you contract to the time that you start working. Some ways to do that is you guarantee it. The easiest one, you just guarantee your price for so many days or weeks, right? This is good for 30 days or 60 days. If you know there's going to be some flexibility because they're not sure when they're ready to start. Another one would be that you're going to cover the first 2 or 3%, and then after the first 2 or 3% increase, the owner then will start covering that cost. So it's just something to think about. Best practices to avoid claims. Number one, have a good contract. Number two, if you start having a dispute, don't panic.
Can I ask
Go ahead.
Okay, so have a great contract. So for all the different small business owners, is that something they can contact you for?
Yeah, absolutely.
Okay, so whether they have no contract and you can help them to get what they basically need, a good starter
Right.
pack. And then, or they currently have a contract that you want to review
Update.
and update.
Yep.
Because it needs to be updated.
It needs to be updated. You should update your contract every.
Can you repeat that question? They couldn't hear the question.
Oh, they couldn't hear the question? What Lisa asked, is that something that we can assist with? And the answer is yes.
What can you?
The question Wow, it's working. The question was, if you're a small business, medium-sized, whatever business owner, and you do not have a contract, you're not using contracts in any capacity, that's something that your firm can help with.
Absolutely.
And that you do that all the time.
Yeah.
If you have a contract, no matter what that contract may be, you need to get it updated and reviewed. I know that much.
That's
And you
correct.
do that as well.
Correct.
Okay, I just wanted to point that out.
Correct, thank you. And really, that's one of the things that leads to disputes, right? Because you have a contract, and what I see happens more often than not, because a lot of people get their hands on that contract in your business, I make changes to the contract, and then I use that change version. And those changes were unique to the project I had with David, and I forget about those changes. And then I enter into a new contract with Lisa, and we make some more changes. And over time, those changes can really alter that contract, and the rights that you once had and the protections that you once had no longer exist, or they're watered down or otherwise altered. But the big point, if a lawsuit is filed, don't panic, don't destroy evidence, and don't speak without thinking. Strongly recommend contacting a lawyer before you get too deep, because a lot of times you try to manage the problem, hoping it goes away, and words have meanings, and if you say the wrong thing, that email is going to be Exhibit 1 in the lawsuit with your contractor, and it could have been well attended, but now you got a problem, and it's going to cost a lot more to dig yourself out of that problem.
Right.
How often should you look at your contract and make changes?
I would say Sure. The question was, how often should you do a contract review? And I would say every couple of years. And certainly, if you have a dispute, absolutely, that's like a red flag. You want to get it looked at. But every couple of years, and really, one of the things you can do as a business is just maintain a good protocol for who revises your contract documents. So I don't come in and I take your master contract and I completely revise it, and you think you're still, you know what I mean? And then we have that problem going forward. Any other questions? I'm going to talk very quickly about leases. The one lease provision I really want to talk about is warranties and representations. The reason why this is important is because it came up a lot, especially as a result of the pandemic. And now they're talking about monkeypox. But again, it's another provision that for a period of time people didn't pay attention to. A warranty and representation is a statement of fact that the parties relied upon when entering into the contract. Who here has a commercial lease? Just show of hands. Okay. And when you picked your space, you probably picked it for any number of reasons: location, proximity. If it's in a shopping center, things you're thinking about is the brand of that shopping center, the foot traffic at that shopping center, who the other tenants are. I will tell you, I've had several cases where the landlord makes a lot of lofty representations about, I'm going to enter into leases, I'm going to enter into other leases with these great companies. I'm going to have a Capital Grill is going to come in. I'm going to have a Louis Vuitton's going to come in. All these great tenants are going to be there, and they're going to bring business to you. And you're like, that's great. I'll pay a little bit higher rent, but I'm going to make money off of it, right? If they're making those representations, you need to make sure that they are in the lease itself. Very specifically what those representations are, because if you don't, the landlord in every lease is going to include a disclaimer, and that disclaimer is generally going to say something effective. There are no representations and warranties other than what's specifically written in this lease, okay? And those disclaimers will be enforced, and if you're told that they're going to enter into a lease with this other tenant and it doesn't come to life, if you're told that they're going to do some new construction or maybe bring the metro here, right, things that you're relying upon to move it in that space, and if it's not in that lease and it doesn't happen, you really don't have much of a remedy other than to stay in that lease and pay your rent. All right, so that's probably the most important provision that I would focus on. There's others about defaults, and there's an example disclaimer provision that we can talk about. There's some slides in there for text that I won't cover due to time, but I'm happy to talk to you afterwards. And the other thing, just briefly for best practices, is have that force majeure clause in there. It not only comes up in construction cases, but same thing. What happens if you are GAP? I'm going to use GAP because this is a real case. It's not a case I handle, but it's a real case in New York. And the mall is shut down because of COVID. And you can't have customers come into your store. Do you still pay rent? Court said you do, because the force majeure clause in that lease did not give them an opportunity to avoid paying rent during the shutdown. And there was a lot of reasons why the court ruled the way it did. So just make sure that you are anticipating those things. And just like a construction contract, if you have a lease or you're going to enter into a new lease, or an opportunity might present itself with a recession for you to renegotiate the terms of your lease, because you might be considering, you'll see that come up. Consider reaching out, and again, we do leases, a lot of firms do, but we have people that do commercial leases all the time. Again, it's not as expensive as you probably think it would be, but absolutely consider having a lawyer assist you with that, because again, it could save you a lot of money if you get into one of those disputes down the roads.
Yep.
So,
So everybody here that has a commercial lease, catch up with Mark afterwards, because you definitely want, do I need to speak into this? Everybody here who has a commercial lease, catch up with these guys afterwards and get their information. I think you have pamphlets, because you definitely want to get that reviewed ASAP.
thank you. I'm
Thank
gonna turn
you,
it to
Mark.
Russell.
Morning, everyone.
Good morning.
So, just show of hands, how many people here have employees? Looks like almost everyone. All right, so this is particularly pertinent. I could spend the next 24 hours talking about what I'm going to cover in the next half hour. Then I could spend another 24 hours talking about how that's all impacted by pandemic and COVID law. So I'm going to be concise and high level, and what I would suggest to everyone in the audience is, as I go through this, you think about how this affects your business, because ultimately, employment law, while the law is black and white, written down, a matter of statute, it's really about dealing with people, and it's important that we understand how, not just to comply with the law, but how to actually effectively manage people and to make this work in a practical way. So what we're going to do this morning is go through the life cycle and the different types of documents, the different types of issues that arise for employers with respect to employees. So the starting point for that is the hiring process. And anybody who's tried to hire in the last 6 months or so understands that it's a hard market right now. Recruiting and retention is a tremendous challenge. It's probably one of the biggest, if not the biggest challenge that employers are facing right now. So it's important, not only that employers focus on, the right ways to attract employees and potential employees, but doing it in a compliant manner as well. So, and this is a good primer for me, because later this afternoon I'm participating in an interview for somebody with our firm, so I'm going to brush up on this right alongside you guys. So things that you should do in an interview process. You want to be neutral criteria. Obviously, you can run afoul of the law when you start making decisions based on protected classifications or other things that are unlawful. You want to be clear. You want to understand what the job is about. You also want to ask open-ended questions. And this is particularly challenging when lawyers try to do interviews, because we always want to put words in other people's mouths, and we ask a lot of leading questions. As the worst thing you can do in an interview. It's other than, maybe it serves as a basic intelligence test. Hey, this job's really important. You got to work long hours. You got to do this. You got to do that. How do you feel about working long hours? That's a really bad question, because if the person's paying half attention to you, you're going to say, oh yeah, sure, I work long hours, no problem, and you're not going to get an honest answer about it. So instead, I think it's usually better to ask more open-ended questions like, tell me about a time when you had a challenging customer, you had a challenging boss, how did you handle that? And you want to get people talking about telling their stories and giving examples from their past about how they handle certain things, and you can evaluate that as opposed to them just giving you the high-level, conclusory right answer because you fed it to them. As you can see on the slide, I think it's also important to ask, and this can be done on a job application as well. You know what the job is. The job description has been shared with you. Can you perform the essential functions of this job with or without a reasonable accommodation? As an employer, you're not allowed to discriminate based on someone's status of having a disability. So what the law requires, is that you make reasonable accommodations for someone with a disability. So this is the proper question to ask, because if you have to make an accommodation, you have to make an accommodation. You can't not hire someone because you might have to make an accommodation. In terms of what not to do, there's a list on the slide of the various protected classes. There are more. That list is growing and evolving. Don't ask about those things. Don't retaliate. For example, I've had clients say, "Oh, I looked this person up. They filed a lawsuit against their prior employer. I'm not going to hire them." That's retaliation. Can't do that. So there's a whole bunch of different things that you should be cognizant of. And again, and this is a common theme, whether it's in the hiring process or the managing process, you want to ask questions that are designed to get to performance, because that's what we really care about as employers, performance. We don't care, what your background is. We don't care what gender you are. We don't care, about any of these protected classifications. It's just not super relevant, because what we really care about is, are you able to perform? Will you perform? Are you performing? And those are the types of questions that we want to ask. Now, as you bring on employees, you're bringing them into kind of your inner thinking to some degree. Depending on the employee, it may or may not, be that deep, but you're letting them in. You're letting them into your shop. You're letting them into your office. You're letting them into your factory, whatever it is. So there's certain things that I think are pertinent for an employer to do to protect that, and that's non-disclosure. That's protecting proprietary information. That's confidentiality. That's non-compete. Now, kind of where we are in the DMV area, that these things can vary. There's different laws in Virginia than there are in DC than there are in Maryland. So you have to be very, very cognizant of that, and you have to navigate that with a lot of precision and care. But you want to at least have the conversation about, do I want to, assuming that I can, do I want to have a non-compete provision for this employee? Or do I want to have a non-solicit so that they don't go after my customer? I'm opening up my Rolodex to this person. I don't care if they go work for my competitor, but I don't want them taking my clients with me if they do. That's what a non-solicit would cover. And similarly with respect to intellectual property rights, it's the same basic idea. Whatever gets created on my dime, under my roof, should belong to me, and I don't want employees to be able to just take that and make it marketable and sell it without me. That's there for me. I'm the one funding the R&D essentially when it comes to that. So that should belong to me as well. So these are important considerations. Again, it's not every employee that you need to deal with this on, but it's something that you should ask a question about and where that might apply in your business.
Russell, quick question. With respect to the safeguarding your business issues you just discussed, your non-disclosure, your intellectual property, how important is it that you, as the business, enforce those rights consistently?
Yeah, I mean, it's important, obviously, because once there's a leak, especially with confidential information or things that can be trade secret, once it gets out there in the public domain, it's no longer confidential. It's no longer trade secret. I mean, even when we draft these agreements, we say, this is how we define confidential information, and we give a nice broad definition of it. But one of the carve-outs from that often is things that are already in the public domain, things you learn from someone who, someone other than us that maybe already is authorized to have that information outside the scope of our business. So once you let it out, you can't put the toothpaste back in the tube.
And the point I just wanted to make, sorry, Russell, was other litigation that we do is business litigation dealing with trade secrets and claims of trade secret theft and violation. And as an employer, if thing is a trade secret because it's secret, and you can get all these great policies in place, but if you don't enforce them and don't protect it, you're going to lose that right. So just like we were saying earlier, the kind of theme with the contracts, make sure you're consistently enforcing them.
Yeah, well, and that's a common theme in employment. I'm pretty confident that if we draft a policy, if we draft an agreement, it's going to be a pretty solid policy or agreement the day we give it to you. But then how it gets used, what exceptions get made, how it practically gets rolled out, it starts to, Mark, like you were saying earlier, people make changes, people do different things, and it starts to kind of spiral out which is why it makes sense to bring it back periodically and tighten it back up. So with that point, I wanted to ask another question to the audience here. I know most everyone raised their hands when I asked if you have employees. Next question is, how many of you have an employee handbook? Okay, so that's a much smaller percentage. And of those who have employee handbooks, how many of you have updated that in the last 12 to 18 months? All right, nobody. So I view employee handbooks as like going to the doctor for a checkup. And this is a process solution to what we were just talking about, where things start to spiral and expand. I think you should get your handbook looked at on an annual basis, because every year the legislature will change laws and things will change and evolve, and you have to pull it back together. So I think it's an annual thing that needs to be done. Just like going to the doctor for a checkup, if you push it to 18 months, if you push it to 2 years, 9 times out of 10, you're going to be fine. But my official recommendation is this should be an annual thing. So what do you need in an employee handbook? You need to set up what your company is about, what's important, what we're going to do, what we do, who we are, where to go when you have issues, and where to go when you have questions. One of the important reasons of having a handbook is, while you're not necessarily explicitly limiting liability by having someone sign off on a handbook, you're building in evidence. When we get called and say, hey, I want to fire this person, or this person's making a claim against me, and they're saying we didn't listen to them when they raised a discrimination claim, it's great to have an employee handbook that says this is the exact procedure you need to follow to raise these claims. These are who you should go to. This is what you should say. This is how we tee it up. That's really important, and that's really helpful when we have to defend issues. And again, it also functions as a reference guide. I mean, candidly, at this point, handbooks are 25, 30 pages minimum. Some clients have 100-page handbooks because they stick everything in them. I've never met an employee that reads that handbook cover to cover. So it's not, it'd be like reading the phone book. That's not what it's there for. It's there to, have the first couple pages set the tone of what employment with your company is going to be like, to include the important information as a reference, so that when an issue arises, someone can look at the table of contents, figure out what section to read so they know where to go, so that if you get challenged on something, you've got the right policy in place already. And to use as you manage, it's something to help you manage. Say, hey, look, we've got this policy, you got to comply with it. And you can lean on the policy as the bad guy, as opposed to you, the manager, being the bad guy. So again, this is a little bit more detail on what I think belongs in a handbook. If you don't have these policies, you should have these added to your handbook. There's a lot of discretion. So, what we do as an attorney who would work on an employee handbook, we have our templates. We're not starting from scratch, and we can start with the client's handbook as well. But we're going to ask questions, and it's a really good diagnostic process for me, because I'm going to ask questions. I'm going to look into kind of what are you doing already? What is your leave policy? Is that compliant? And it's going to force me to ask you questions. It's going to force you to think about the answers to those, and then we can make a conscious decision about what we want to do going forward that's both best for the business and compliant with the law. Because again, I can write a perfectly compliant handbook, but that doesn't do a whole lot of good if it's not best for your business. So through this process, talking through these different policy provisions, we can arrive at not just a compliant solution, but a real-world practical business solution. So something I want to spend a little bit more time on, because unfortunately it's pretty prevalent, is harassment and discrimination in the workplace. Obviously there are things, when you have employees, as all of you raise your hands know, you can't control them. You can manage them, you can influence them, you can nudge them in the right directions, but they're people that are going to do what they're going to do. And what we do as employers is to protect against that risk as best we can. So again, we want to have all these policies that I've been talking about, but we specifically want to be clear about harassment and discrimination, because that's something that as an employer can get you sued. So in addition to having the policy in the handbook, I strongly recommend doing annual training on harassment and discrimination. Not that those issues change that much from year to year, and the right way to behave in the workplace is still the right way to behave in the workplace year after year, but because it's an important reminder. And it sends the message from the management side, this is really important, employees, pay attention to this. We really need you compliant with this thing. We think it's important enough that we take 2 hours every year and make you work through this training and give you a chance to ask questions and to learn. And of course there are tweaks that evolve in this area of law, but we think it's really important, and by elevating it that way as a management team, you're really sending that message. In addition, it's a really useful risk mitigation tool, because not only might you better manage your employees by doing so, you look a lot, if someone challenges you or someone sues you with respect to a claim of harassment or discrimination, the fact that we've got a policy, we've got a reporting procedure, we do annual training, we make everyone sign off on that annual training, we confirm that they've completed the annual training. That makes you look like a pretty on top of it employer. But then what happens when there is an issue? Number one, zero tolerance. Nobody in the company is allowed to get away with anything, and it should all be documented. And I think it makes sense to engage in what's known as progressive discipline. Progressive discipline just means, the more times you screw up, the more severe the punishment gets. And of course, there are times where you just jump. The conduct is so egregious right out of the gate, you skip all the steps and you terminate the employee. That's still permitted within a progressive discipline process, but you don't want to let anything slide. So sometimes, it could be I hear this all the time from people who are accused of harassing someone in the workplace. Oh, it was just a joke. I was just trying to be funny. I didn't mean for the person to take it that way. And, when I do training, I have a slide, and I always point out that's my favorite slide in the whole presentation, that says impact is greater than intent. And that's true, I think, across the board when managing and dealing with humans, but it's very much true in the context of harassment and discrimination, because just because you thought you were telling a joke, just because you thought you were going to be funny, that doesn't, that just doesn't cut it when the impact is that someone feels less than in the workplace, or someone feels excluded or harassed, or has a harder time, being able to do their job because you thought you were being funny. So we want to make sure that we manage that. Now, that person who tells, an off-color joke, that person doesn't necessarily need to be terminated. That's why we have progressive discipline. So maybe it's a warning. Maybe it's one-on-one training. There's different, depending on the situation in the company, there's different steps that can be had, and there's a whole host of them. The point is, from my perspective, that if you don't address it, you're accepting and condoning it, and that will certainly get you in trouble, not just in the legal respect, but you're going to lose employees, which, rewind 10 minutes, recruiting and retention is the biggest concern for employers right now. You can't afford to lose employees because someone, can't behave themselves in the workplace. All right, so shifting gears a little bit, this is kind of on the opposite end of the spectrum. I like to, when I think about employment law, you've got harassment, discrimination. It's very personal. It's very, one-on-one, he said, she said type situations. And then on the other end of the spectrum, you've got compensation issues, which is math heavy and has to do with counting hours worked, calculating pay, and making sure that you classify employees properly. With respect to wage and hour issues, that the simple version of it is, if you're non-exempt, that means the employee has to be paid minimum wage for all hours worked, as well as time and a half of the regular rate for hours worked over 40 in a week. So that's the simple starting baseline for that. And in my experience, there's three main buckets of errors or places where wage and hour compliance goes off the tracks. The first one is proper classification. And by classification, I mean, are they non-exempt? Are they entitled to minimum wage and overtime? Or are they exempt so that you don't have to do that? So what happens a lot of times is I get well, I pay that person a salary, so they're exempt. That's unfortunately, that's not the entirety of the test. There are a number of different tests, and that's a piece of most of them. But the other piece is their job duties still have to qualify as exempt. So just paying someone who's doing non-exempt work a salary does not make them exempt. They need to be also qualified under the job duties test. So making sure that you're running through that process, and again, you're being conscious about the decision you're making whether to classify someone as exempt or non-exempt, because what ends up happening if you misclassify someone as exempt and they're really non-exempt and they come back and they file a lawsuit, you didn't track their time, so you don't even know how many hours of overtime that they worked, and every one of those complaints that I see say they work 60 hours a week. I mean, it's never, I worked a little bit of overtime, it was 45 hours a week. You always come in shooting for the moon, and it's 60 hours. So, again, it's really important to get it right at the classification stage, because that can then derail you for the other parts of it. The second piece being timekeeping. So you want to make sure you're keeping accurate time. And by that I mean, tracking the hours. You have a time punch mechanism for non-exempt employees. Particularly in a world where many employees are now working remotely, you've got a process for that. It's electronic, it's digital. For people where you send folks out into the field, you've got an app on their phone that can track that, so they can punch in from wherever they are. And that you're also cognizant of what is work time and what is not work time. So, for example, driving to work is generally not work time, but driving from one work location to the next in the middle of the day would be work time. There can be a lot of nuance around that, and what is home to work versus what is home to work in a different city. Again, that's something that really should be drilled down on specifically. Likewise, if you have people who work, who are on call over the weekends or in evenings, that's another thing you should look closer at to determine whether that's work time or not. The positive is, with any of these issues, is there's usually ways to work it and to massage it so that the costs are, if there's a need for increased costs, it's usually relatively minimal, because we can make the system work it's all numbers, and we can make the system work in a way that's to your advantage. However, we have to have the opportunity to do that. If we just roll with it and then find out we've done it wrong after the fact, that's when you can really get in trouble. And that's particularly concerning because these types of cases can easily be formed as class actions, and then there's multipliers of damages. So you can end up with double or triple damages for multiple people when you just thought you were dealing with one person who had a wage complaint. And the last point on that is, like I was alluding to, is the calculation of the overtime rate. It's time and a half of the regular rate, not time and a half of the base rate. So if someone gets paid $20 an hour, time and a half, $30 an hour for overtime, that part of it's pretty simple. But when you encounter someone who gets paid $20 an hour but also gets paid commissions, now that calculation's more complicated. So I would happily spend the next 10 minutes going through the algebra of how that calculation process works, because I find that enjoyable, but I suspect that many here do not. It's like the one place in the law that I've ever seen there's actually algebra in the Department of Labor's regulations. But suffice it to say that you just need to be cognizant of, well, if I'm paying somebody for work and it's not their standard hourly rate, I should think about how that factors into an overtime calculation. So, an audience question here. If hours are cut below sustainable levels, can you apply for back unemployment from the time the hours were cut? So with respect to unemployment, frankly, I don't spend a whole lot of time with unemployment because I'm usually on the employer side. I am aware that there are policies where if your hours are cut a certain amount and you're sufficiently underemployed, then yes, you can apply for unemployment because and that was highlighted during the pandemic where there were substantial reductions of hours across the board. All right, so moving on. So you've hired your employee, things are going well, you've navigated the problems, but the employee's not performing, and you're getting close to termination. And oftentimes, I get the phone call when someone's accused of discrimination or retaliation or some other form of unlawful termination, and they say, okay, well, if it's not that, why did you fire this person? And the client will say, because they were a lousy employee, they did all these things wrong, they were really stinking it up. And I was like, okay, that's a perfectly valid defense. Just send me all the documents, send me all the emails, send me all the records where you recorded that and created a nice record for me to put into evidence as exhibits 1 through 10. And then the phone just goes blank. And I say, well, you didn't do that, did you? So what if you take nothing else out of the employment section this morning? It's document. It's critical that when there are legitimate performance issues that they get documented. Now, they don't have to, doesn't mean you have to put everyone on a performance improvement plan the second there's a problem. It just means that when there are issues, record them. I'm within our firm, when I do management work, sometimes I'll send an email to myself because now it's time-stamped, it's dated, I took notes about what happened during that call, write in an email, I clicked send, and I put it in my folder for whatever management folder it is. And now I've got a record. So now in 2 months, 6 months, whatever it is, when there's a need for some sort of discipline or up to and including termination, I just point, okay, well, I've been documenting this. This is why we're doing this. We've got a pretty good set of, we have a pretty well-developed record here of evidence that shows this is a performance issue. This isn't discriminatory. This isn't retaliatory. We can go back over the last 6 months, 3 months, whatever it is, and point to things that, I said and did as the manager at the time that are performance related. Because terminating someone for performance reasons, totally acceptable. Terminating them for discriminatory reasons, absolutely not. So I just want to make sure that I know I'm not discriminating, and I know even that client that didn't keep good records isn't discriminating, but it's about proving that I wasn't discriminating or that client wasn't discriminating and creating that record. So that's a really important step in the performance management process, and frankly, I think it's really important from a management standpoint and a morale standpoint as well, because if most employees want to do right, and even if they're struggling, they might benefit from coaching. So having those conversations with employees, expressing to them, hey, this is where you're struggling, this is what I need you to do better, I'm going to measure it, I'm going to measure it as objectively as I can, and we're going to manage your performance. That's managing up and managing out look the same. And I also, subscribe to the belief that no one should ever really be surprised that they're being terminated. If they are, it means you didn't manage them. And that's a failure of management in that scenario. Now, obviously some people are going to stick their heads in the sand. I'm not talking about them, but no reasonable person should ever be surprised that they're being terminated because you've managed their performance, you've addressed the shortcomings, and you've tried to make it work before you've gotten to the stage of termination. Sure.
On that. So we're kind of dealing with an employee that does consistent careless mistakes, where unfortunately those careless mistakes can be not good for the type of work that we do. Every time we have a conversation with a certain employee, is this where we should be telling them, I am noting this down? far as, when we have a review, this is, in a month, this is how many mistakes you unfortunately make.
Right. So the question for those online was, an employee keeps making careless mistakes. How do we deal with that? How do we communicate that with the employee? How do we document it? So I do think that, again, kind of referring back, this isn't discipline, but this is progressive in that sense. So the first conversations are, hey, I need you to do this better. We need to work through that. You need, this is an issue, this is a mistake, we need this to be better. And, maybe you put it in an email just because you're managing. It's not setting up a termination. It's just like, hey, I need you to do better on this. And even if it's a conversation, you make a note of it. You email it to yourself. You put it. You don't have to you don't want to make the employee necessarily feel like, oh, I'm in jeopardy. I'm in trouble. I did something wrong. You just want them to correct the issue. So you don't maybe want to send them the formal, I referred to it earlier, the progressive, the performance improvement plan or a PIP. You don't want to put them on a PIP right away. But maybe at some point you do. And so I think it's a management decision. When am I going to have to fire this person? Because 60 days before that, I want to put them on a PIP. And if it's the occasional mistake, I let them know and I put it in an email somewhere and file it away, no big deal. If it starts to become a chronic issue, now I have to manage it more aggressively. I am going to do a PIP, and short of improvement through the PIP process, now I'm going to be ready for termination. So we've now arrived at the termination meeting. So you've done your homework, you know your reasons, you've done what you need to do to get to that point, you're confident in the decision. 2 points I want to make. Number one, you're telling a person that they're losing their job. That's a lousy thing to hear for anybody. So you want to approach it with empathy. That being said, you've already made the decision. It's not a debate. It's not a discussion. It's not, well, what if I do this? Can I save my job? You're past that stage. You've presumably already managed and gone through that performance management process. So it's your decision. It's done, and I liken it to pulling the Band-Aid off. Thanks for taking the time to meet with me. We're terminating your employment. We're terminating your employment because of chronic carelessness. We've talked about it. The performance just hasn't improved sufficiently. So we need to, so we've made up our mind. We need to move forward. And then you explain you'll get a letter about your health insurance and your other benefits. And here's what I need for offboarding. And I need you to give me the key card back. And if they're on a computer network, you've got it set up so IT is cutting their access. As soon as the meeting is over, during the meeting. So you want to be quick, to the point. I think it's worthwhile to give an explanation, but you're giving like the 1 to 2 sentence explanation. You're not going through the hours of deliberation that you and your management team may have had. Which then leads me to a final point, and it's a way to further mitigate risk, is severance agreements. There are times, for any number of reasons, why you may want to utilize a severance agreement. And by a severance agreement, I simply mean you're going to pay an employee something extra that they haven't earned in exchange for a release, which means they're not going to sue you. And again, like all these things I mentioned, like Mark was saying earlier, these are all legal documents. You can go online and find them. That's a pretty terrible idea. So you should make sure you have one that works for you, and that's right, instead of just Googling severance agreement and pulling the first thing that comes up. But that being said, this is a way to kind of hedge some of your risk. Like, you know what, like we did terminate for performance, but this particular employee came back from a parental leave 2 months ago, and I'm just worried about the timing. So I want to be a little proactive, and I want to try to buy my piece up front. And there's 1,000 scenarios where you might want to buy your piece up front instead of waiting to see what happens. Similarly, there are times where, hey, this is a reduction in force. We've just got too many employees. We feel lousy about it, and we want to compensate you in some way. We want to give you a month's worth of pay just to help you transition. But my feeling always is if you're going to pay something that the employee hasn't, isn't already entitled to, it's worth getting a release back. There may be specific scenarios where, there's a little bit of a tightrope to walk when it comes to making these decisions, but that's, from my standpoint, that's at least a thought process that you should go through with respect to any termination. So with that, any questions?
We handed you two very quick questions.
Sure.
Mine from our viewers.
Sure. Can you charge employees for damage to your company? For example, with equipment and with insurance deductibles. So I'm going to give you the classic lawyer answer of it depends. There are scenarios where you can do that, and there's a lot of you can't do it off the cuff. You have to plan for that. You have to have the right agreements in place. So there are ways to do that, subject to a whole lot of other rules that it implicates, because you don't want to create minimum wage issues by deducting from wages. You can't. You need employee sign off on it. So there is a process for that. So again, that's a specific. It is in theory an option, but it should be part of a plan. I see it most frequently with employee vehicle plans, because obviously the damage can be great when you're driving a vehicle. So again, it's something you could work into a vehicle policy. Next question: if you have young ladies on staff, can you stick with this practice as a safety issue? I'm not sure what the.
David?
The other question around safety, sorry, I was responding to here. Is it a handwriting issue?
No, I'm not sure what the practice it's referring to is.
If you have young ladies on staff, can you stick with this practice as a safety protection for those
What practice?
of hiring young ladies?
Uh,
It's a gender-based question.
Oh,
Well-
so is that her bias if they don't hire men? Is that the question?
Well, they're doing it for the protection of their current staff.
So they're
So-
only hiring,
Question.
I don't
Or
know.
have young ladies and they only want to hire young ladies to protect them, probably from harassment.
I would say that gender should not be a consideration in hiring. I mean, there may be caveats to that in certain very limited industries, but yeah, I mean, if you only hire young women, you're discriminating on people who are not young women, whether that's age or gender of any kind. So, I don't think gender should be a consideration in the hiring process. Sure.
We have a fleet, we have a bunch of vehicles, safety vehicles. When we have people who get in accidents, we do require a drug test. Now with the Virginia marijuana laws, how does that play into, like, if somebody has a medical card for marijuana, how does that play into a test positive?
So the question was about how, having a medical marijuana card and how that relates to drug testing in the workplace, particularly after an accident. I'm not intimately familiar with what the Virginia medical marijuana law says on it, but I will say I'm generally familiar with them across multiple states. And what I would say is that there are protections, depending on the state, there are protections with respect to a drug test turning positive. Some states have it, some states don't. When there's an accident, but I think the baseline is you can't come to work under the influence and doing damage. So if there's a causal connection between being under the influence of marijuana and then you have an accident, that's a different question than if you just do a random drug test and you're positive because marijuana stays in your system for a month and you did whatever you did over the weekend. So it's a little bit of a nuanced question, but yeah, I think ultimately I think you should drug test after accidents. That's for sure. And if that arises, when you get the positive test after an accident, then we can drill down on what the consequence ought to be for that particular employee. Yeah. So number one, I think you want to have an agreement with those designers or those employees that work for you that spell out that it's your property, or you may even have agreements with your clients say that the pictures belong to your clients and that may be licensed to you. So, like Mark was talking about earlier with flow down contractors and subcontractors, same basic concept. If you're limited in your use of those pictures, you want to make sure that your employees are bound by whatever limits are placed on you. Even if they're not, then you want those rights. You don't want them being used by an employee who goes and works for a competitor and says, hey, look at all this great work I did when they were a member of your team. So first off is putting the agreement in place. Secondly, if it happens, there's always the cost benefit of what am I really chasing them? Like, how much is this going to cost to go after them? But oftentimes you can resolve that. You can have a lawyer send that a cease and desist letter to kind of ward off the conduct, and that may be a sufficient way to just put it to rest without having to spend a whole bunch of money litigating, which you probably don't want to do because the risk probably isn't justified by that. I mean, a cease and desist is like the lawyer way of asking nicely, please stop doing this or else we're going to sue you. And, and then at some point, you always have the remedy of going to court. I'm just raising the practical concern that it's not going to be cost effective. You're not going to want to do it. So it takes an hour or two of a lawyer's time to send that cease and desist letter, and then you recalculate after that, because maybe they didn't take the picture down, but maybe they're not posting anything else, and that's good enough. All right, well,
Thank you.
turn it over to you, Courtney.
So good morning, everyone. Now is when we start the portion of today's presentation where we discuss different tips and tricks that you can use to maximize your insurance coverage. Our agenda for this portion of our panel is to discuss different types of liability insurance that you should be familiar with and common misconceptions about those liability insurance policies. We're also going to discuss recent developments in the insurance coverage space and some policy language that you should be looking for in order to broaden or maximize the coverage that's available to you. We'll discuss a win for policyholders seeking insurance coverage for COVID-19 related losses and what to expect in future litigation of those disputes. And then we'll go over some steps that you should take to preserve coverage after a claim has been made. So to begin, I want to discuss quickly that as insurance coverage attorneys, typically we separate insurance policies into two different categories: liability insurance and first-party insurance. Liability insurance comes into play when you have some type of third-party individual or entity that either brings a lawsuit against you or sends a demand letter or any type of communication to you alleging that you are responsible for some type of injury that they have suffered. In the event that that happens, you're going to look to your liability insurance carrier to defend you in response to that lawsuit or demand letter. And then also, if you are ultimately obligated to pay damages to that third-party individual or entity, you're going to look to your liability insurance carrier to indemnify you for the payment that you've made. In contrast, first-party insurance is just insurance that protects you for your own losses that you experience. The most common type of first-party insurance policy that you probably deal with is property insurance. So some common types of liability insurance that you should be familiar with are commercial general liability insurance. CGL policies provide coverage for claims of bodily injury or property damage or advertising injury. And depending on the jurisdiction or the state that you are litigating in, that bodily injury coverage grant in a CGL policy may also extend to claims of emotional distress. Similarly, that advertising injury coverage grant in a CGL policy, depending on the policy language that you have at issue and the state that you are in, could extend to claims that you've committed trademark or trade dress infringement. Directors and officers liability insurance is going to provide coverage for directors and officers of an organization, as well as the organization under certain circumstances, for claims alleging that you've engaged in mismanagement. Mark mentioned earlier the concept of self-dealing. That would be something that you'd look to your D&O insurance policy to provide coverage for. Claims of fraud, breach of fiduciary duty, negligent supervision. Those are all types of claims that you are going to go to the D&O policy to assess whether or not it provides coverage for you. An errors and omissions liability insurance policy is going to provide coverage to professionals when they either negligently act or commit an error or omission in the performance of their professional services. And then employment practices liability insurance is going to provide coverage for dozens of different types of claims. Russell asked earlier today how many of you have employees, and I think most of you all raised your hands. And then he discussed this concept of different ways to safeguard your businesses. Another way to potentially safeguard your business would be to consider purchasing employment practices liability insurance. Some of the types of claims that are going to be covered under this insurance policy are claims of harassment, claims of discrimination, and claims of wrongful termination. One of the trends that we've seen in the employment practices liability space currently has been looking to those policies to provide coverage for COVID-19 related losses. So we've seen this happen where employees allege that their employers have failed to implement appropriate safety protocols and procedures to protect the employees and their customers from contracting COVID-19. Under these circumstances, we then see employers, companies, look to their employment practices liability insurers to provide coverage, so defend them in response to those claims. And then if ultimately they are obligated to pay damages to those employees, to provide indemnity coverage to them in response to those claims. Another trend that we are seeing in the employment practices liability space has to do with biometric privacy legislation. So this legislation is not very widespread at this point. In 2008, Illinois was actually the first state in the country to implement biometric privacy legislation. What it does is govern the collection and the storage and the use of biometric information, and these are unique biological identifiers like fingerprints. And the way that it ties in with EPL insurance is that we've seen cases where employees will claim that their employer's use of something like a fingerprint-based time entry system violates that biometric privacy legislation. Then employers will look to their EPL policies to provide coverage for those claims. It's becoming more significant because more states are now considering adopting similar legislation. In 2021, the Maryland legislator introduced legislation that was based on that Illinois law. So EPL policies are going to, we expect litigation to increase in that sphere, and we expect EPL policies to come into play more frequently. Some common misconceptions about liability insurance. So these are some points that you may have heard brokers or insurers or just other people in your industry say about liability insurance policies. The first is that all liability insurance policies are the same. This is completely incorrect. There are literally thousands of different liability insurance policy forms, and minor variations in language can be the difference between you getting coverage for a claim and the insurer being able to properly deny coverage for a claim. So one of the things that we recommend our clients do when they are going through the policy renewal process is engage their insurance broker, and then also consider engaging coverage counsel like Offit Kurman to take a look at your insurance policy and the language that's being used and assess whether or not there is broader language that could be used to increase the scope of the coverage that's being provided by your policy. And then your broker would just reach back out to the insurance company and ask for modifications to be made to your insurance policy. The second misconception is that there is no insurance coverage for intentional conduct. This is going to be a state-specific rule. Depending on the state that you are in, when you have a dispute, you can get coverage for intentional conduct if there is some type of determination that you didn't actually intend the resulting harm. So an example of this would be if I shot a gun up in the air and then the bullet hit a bystander. I intended to shoot the gun, but I did not intend for the bullet to hit the bystander. So in states that are prescribed to this particular rule, I would still be able to get coverage under my liability insurance policy, even though most liability insurance policies contain exclusions for intentional conduct. The other thing that you'd want to look for in your liability insurance policies that include this intentional conduct exclusion is language that limits the application of that rule to situations where there has been some type of final adjudication by a court of law that you in fact did engage in intentional conduct. It shouldn't be enough for some third party, individual, or entity to just allege that you intended to harm them. They need to prove it in order for your insurance company to deny you coverage. The third misconception is that giving notice of a claim will increase your premium. Not always the case. That depends on a lot of factors, including the costs and significance of the claim that you've made, as well as market conditions at the time that you are renewing your policy. The fourth misconception, your insurer denied coverage, so that's the end of that. One thing that we always say to clients, and really anyone that comes to us to tell us about an insurance issue, is do not take your insurance company's no for an answer. If you have a claim that's made against you, you submit notice to the insurance company of that claim, and the insurance company denies coverage, I strongly suggest that you engage coverage counsel to assess the facts of your claim as well as your insurance policy, and to make a determination about whether or not the insurance company properly denied coverage. And if they don't, I suggest that you engage coverage counsel to pursue your insurance company for coverage. The fifth misconception is that making a claim will harm your relationship with your insurer. That's false. The entire purpose of the insurance is to provide coverage to you in the event that you are subject to a claim. So anytime you do receive some type of lawsuit or demand or communication alleging that you might be responsible for causing injury to a third party, you absolutely should provide notice to your insurance company, and you should do so as soon as possible. And then the last misconception is that all insurance law is the same. That is not the case. Every state has its own insurance law, and different states and different courts will construe the same policy terms and interpret the same language differently. Let's talk about additional insured coverage. So for anyone that is unfamiliar with the concept of additional insured coverage, this comes into play when a named insured promises to purchase coverage for the benefit of another party, which would be the additional insured. This frequently happens within the context of a contractual relationship. The different types of contracts that typically include additional insured provisions or promises to purchase additional insured coverage are loan documents, commercial leases, sales contracts, form purchase agreements, and construction contracts. Now, every type of liability insurance is not going to be a policy that you should agree to provide additional insured coverage under. Typically, we only see companies agreeing to provide additional insured coverage in connection with commercial general liability insurance policies that provides coverage for bodily injury, property damage, and advertising injury. We see it in connection with the umbrella and excess liabilities that provide coverage over those commercial general liability insurance policies. We also see it sometimes in the auto liability insurance space, as well as in connection with builder's risk insurance policies. So there are many different types of additional insured coverage forms that are available in the insurance marketplace. For key vendor and contractor relationships, you can consider specifying which version of the additional insured endorsement you want your vendor or subcontractor to purchase to protect you. The most broad additional insured coverage that's available includes language that the insurance company is going to provide coverage to the additional insured for liability that arises out of the named insured's work. This is broad because many courts have looked at this arising out of language in the policy, and they've found that in addition to getting coverage for liability, vicarious liability based on the conduct of your named insured or your subcontractor or your vendor, you can also get coverage under that named insured's policy for your own negligence. The insurance industry responded to numerous court decisions saying that the insurer of a named insured has to also provide coverage for the additional insured's own negligence by narrowing the scope of coverage provided in the subsequent additional insured forms that they've created. So in 2004, the insurance industry came out with a new form that limits coverage to additional insureds for liability that's caused in whole or in part by the named insured's conduct or work or operations. Courts have found that this caused in whole or in part language does do what the insurance industry intended it to do, which is narrow the scope of coverage provided by the additional insured policies. And they now say this language means that an additional insured can only get coverage for vicarious liability. It can no longer get additional insured coverage for its own negligence. In 2013, the insurance industry further narrowed coverage provided by their additional insured endorsements by limiting it in two ways. The first is limiting coverage to the extent permitted by law. And then the second way is that they've limited coverage so that the insurance afforded to an additional insured is not going to be broader than you are required by the contract or agreement to provide for an additional insured. So many insurance companies have taken this language and they have argued that it allows them to do something that we call tying the coverage to the contract. So let's say you enter into a contract with your vendor or subcontractor, and that contract includes an indemnity provision that specifies the circumstances under which that vendor or subcontractor is obligated to indemnify you. And they are very limited circumstances. If there is, in fact, an incident that leads to some type of bodily injury or property damage, and you are looking to the vendor to indemnify you, but you're also looking to their insurance carrier to provide additional insured coverage, the insurance carrier is going to say, we are also only obligated to provide coverage to you in those same limited circumstances that are contemplated by that indemnity provision in the contract. So if you are a company that's being asked to procure additional insured coverage for another individual or entity, there are some factors that you should consider in favor of agreeing to purchase that coverage and also in favor of deciding not to agree to purchase that coverage. The factors that are, the factors that would weigh in favor of deciding not to add an additional insured are, it may increase your premium. If the carrier is agreeing to provide coverage for you as well as your additional insureds, their risk is increasing, so it is possible that they are going to raise the price of your insurance policy. Another factor would be potential waste to your insurance policy limits. Additional insured coverage is not some separate type of insurance policy that you're purchasing. It is simply a provision or an endorsement that is added to your own insurance policy that frequently just says, if you've agreed to purchase additional insured coverage, or you have a contract that requires you to purchase this coverage for another entity, then this policy is going to provide that coverage for you. But if your additional insured has a claim made against it and experiences a loss, and they look to your insurer to provide coverage for that, and the insurance company does in fact provide coverage and does make a payment to your additional insured, it's going to decrease the amount of policy limits that are available to you in the event that you also experience some type of claim and you also need the insurance company to respond to that. The third point is that you may be obligated to pay the deductible in the event that your additional insured has a loss. The factors weighing in favor of deciding to add an additional insured would be first, that it's required by the contract if it's necessary and you want that contract, you likely are going to agree to purchase the requisite coverage. Otherwise, you would likely need to get your contracting party to agree to waive the insurance requirement. The second factor would be that it supports your contractual indemnification obligation if you lack the assets to comply with a contractual indemnity provision. The third factor weighing in favor of deciding to add an additional insured to your policy would be that even if you do have the assets to comply with your contractual indemnification provision, the additional insured is probably going to look to the insurance carrier to pay for the loss instead of looking to you. Likely because the insurance companies often have deeper pockets, and also that's the entire purpose of the policies, to provide coverage in the event that there's a loss. Oh, got it. Okay. Next, I wanted to talk about cyber insurance for a moment. So incidents of cyber and ransomware attacks continue to rise. Hiscox Insurance Company regularly does a report where they survey businesses across the world, actually. They also survey insurance companies and other cyber insurance professionals. And they create a report. Their 2022 report provided that 48% of companies reported a cyber attack in the past 12 months, which was up from 43% of companies reporting similar instances in the previous year. The report also noted that COVID caused companies to increase their reliance on cloud services, which has resulted in an increase in cloud service-based cyber attacks. The median cost of a cyber attack is just under $17,000 for companies. And to help offset the cost of those cyber attacks, many companies, approximately 64% of the respondents to the Hiscox survey, have now purchased cyber insurance as either standalone policies or as a part of a larger insurance package. Cyber attacks can be sponsored by a variety of individuals. Sometimes it's just individual actors looking to profit from a breach. Sometimes they are sponsored by government entities. The example that we've provided is the 2020 SolarWinds attack, where U.S. officials believe that Russian hackers were able to breach SolarWinds computer systems, and then they had access to not only SolarWinds computer system, but because it was a technology-based firm that sent regular updates to all of their customers, they were able to gain access to their customers' computer systems as well. And this was an attack that wasn't discovered until several months after it actually happened.
Courtney, does cyber coverage also include, for example, when you get the malware that locks up your account? Does it include that?
Yes.
For business interruption?
So cyber insurance policies, actually, they tend to combine different elements of what we call first-party insurance and liability insurance. And many cyber insurance policies include what we call a ransomware coverage event. So in the event that you receive a message from a hacker that they've taken over your computer, they've locked up your computer system's operations, and they are not going to free them up unless you pay a ransom. If you have a cyber insurance policy that includes that ransomware coverage grant, it's going to provide coverage for the ransom payment that you're being asked
Isn't
to
that
pay.
crazy?
Also, the business interruption point that you made, cyber insurance policies typically also include a coverage grant for business interruption losses. So these are just any profits that your business loses out on because your systems were down and you're unable to operate normally. Sometimes it's also any increased operating costs that your business experiences. In the event that your company sustains those types of losses, cyber insurance policies, which should include that business interruption coverage grant, they're going to jump in and provide coverage to you under those circumstances.
One follow-up question. How many run businesses out of their home? A couple?
Homeowners insurance?
We've run into this a couple times, and Courtney's point about, consulting with insurance counsel with your broker. Not all brokers are created equal. Some of them are really good, and they're going to ask you questions based on experience to help you navigate to make sure you have full coverage. Others don't know what they don't know if you don't share with them. A lot of times we're kind of out there left figuring this stuff out on our own, right? You call the broker, you say you need coverage. You want to make sure that if you're running a business out of your home, you're probably going to have homeowners insurance and things like that. Your home may be in your name, but your business likely is in a different name, like an LLC or some sort of corporation. Make sure that business that you're running is a named insured on the policy, because if it's not a named insured, Courtney, are they covered?
They are not covered. And typically, when you are running a business, you want to have insurance that's dedicated to covering your business. You don't want to rely on your homeowner's insurance policy, because many homeowners insurance policies include a provision saying that the coverage provided under that policy does not extend to your business activities.
And if you're running multiple businesses, you might have your primary business, but then maybe you have rental properties or whatever it is, and you have different entity names. Definitely speak to someone like Courtney and have her help you navigate that issue with your broker and explain to your broker, because they're not lawyers, they're salespeople, right? They're going to sell a policy to you, and they kind of generally know what to give you, but someone like Courtney will know the exclusions, and that's the language, the exclusion, the things that are not covered, to make sure you have those put in, that you're not, that your claim that you're trying to protect against is not excluded, that they have the proper language in the policy.
I have a quick question. So we are in like a co-working space where we use 2 to 3 offices, but everyone uses the same Wi-Fi, so it's not
Okay.
individual. So how does that work into our cyber insurance that we currently have? Is that something that we have to disclaim to them where we are in that situation to be protected?
So the cyber insurance market is new. There are thousands of different cyber insurance policy forms available, which also means that the underwriting process for cyber insurance is going to vary widely depending on which insurance carrier you go with. And typically in the underwriting process, the insurance carrier is going to request information from you that they deem pertinent in making a decision as to whether or not they are going to actually offer you insurance coverage and deciding how much coverage they're going to provide you. Whether or not that's something that you should disclose to the insurance carrier during the underwriting process is really going to be based on whether or not that's a question that's actually asked of you by the insurance carrier. If it's not a question that's in your policy application or that's sent to you by the broker during the underwriting process, then the carrier likely doesn't deem it pertinent to making a determination as to whether or not they're going to provide coverage or what type of coverage or how much coverage. But that is something that you should communicate to your broker, just so that they know that that is another risk that's there, and they can make sure that they are looking for a policy that is going to respond to that risk appropriately in the event that you actually are the victim of a cyber incident.
Okay, so we have about a few more minutes.
Okay,
And then we're going to take some questions.
I'll speed it up.
Okay.
So in response to the rise in cyber attacks and the growing insurance market, one trend that we are seeing in the cyber insurance market is that the market is beginning to harden, and insurance companies are beginning to increase premiums associated with cyber insurance policies and limit the coverage provided by those policies. This is just different types of coverage that you can typically find in the various cyber insurance policies that are on the market. Mark mentioned ransomware coverage, which is going to be considered first party coverage grant. He also mentioned business interruption coverage. That's actually one of the key coverage components that we recommend clients make sure they have if they are going to purchase cyber insurance. Another is payment card loss coverage. This comes into play if you're a company that deals with customers' credit card informations. In the event that your company is the victim of a cyber attack or a data breach, banks are going to pursue you for the amount of money that they spend replacing your customers' credit cards. And that's considered payment card loss. You want to make sure that if you purchase cyber insurance coverage, if you deal with credit cards regularly in your business, it includes this coverage grant. What's excluded under your cyber insurance policy? These exclusions are actually pretty typical of every type of liability insurance policy. The intentional, dishonest, and fraudulent acts exclusions is one that I talked about a little bit earlier. Other insurance exclusions, typically you might have policies that have other insurance provisions that limit the scope of coverage that's provided when you have other insurance policies available to respond to a loss. Some cyber insurance policies completely exclude coverage if you have other insurance policies that are available to respond to a loss. There's also exclusions for civil fines and penalties. One way that we recommend policyholders seek to narrow the application of this exclusion is asking the insurance company to include a provision that it only applies if there is some type of criminal fine or penalty. An active war or terrorism exclusion is significant because, as we discussed a little bit earlier, government entities are now the actual perpetrators of cyber attacks on U.S. businesses. And then the laptop exclusion bars coverage for the replacement of actual physical devices that sometimes are damaged following a cyber attack. So a quick checklist. One key that I want to point out from this slide is that when you are purchasing cyber insurance coverage, and really any insurance coverage, pay attention to whether your insurance company is agreeing to provide coverage to you, but with a sub-limit of coverage. So typically your insurance policy is going to have a limit of liability. You might have a policy that provides you with $2 million in coverage in the event that some claim or act or occurrence occurs. But then there are specific coverage grants that include sublimits of coverage. Sometimes it can be as low as tens of thousands of dollars. So your coverage is not going to be as broad as you thought it was if there's a sublimit of coverage associated with a key coverage grant. As I mentioned before, cyber insurance policies often include other insurance provisions. That's typical of all liability insurance policies. This is because you can also look to your traditional liability insurance policies to provide coverage for your cyber-related losses. In the last 2 years, there have been court decisions that have come out saying that commercial general liability insurers have an obligation to respond to cyber losses. Crime insurance insurers have an obligation to respond to cyber losses. Errors and omissions insurance companies have an obligation to respond, and property insurance under certain circumstances has had an obligation to respond to cyber-related losses. Briefly going to talk about the current state of COVID-19 insurance claims. This has actually been a hotly contested issue over the last 2 years. Typically, companies that have been negatively impacted by the COVID-19 pandemic are going to look to their property insurance policies to provide coverage and help mitigate some of the losses they've experienced in connection with the COVID-19 related pandemic. However, so far, policyholders overall have not been largely successful in pursuing these claims against their insurers. They've been more successful at the state court level than at the federal court level. Let's talk about the reason that policyholders have not been successful in pursuing these claims. Your property insurance policy is going to provide coverage when there is some type of direct physical loss or damage to property. It's going to provide the property damage coverage, and then also it's going to provide what we call time element coverage, which is that business interruption coverage that Mark mentioned earlier, that coverage for the increased costs of operating that your business expends in the event that there's some type of physical loss or damage to property, or lost profits that you suffer as a result of the physical loss or damage to property. However, within the context of COVID-19, many courts are finding that there is no coverage under the property insurance policy because COVID doesn't actually physically alter property. However, in July of 2022, a California appellate court recently came out with a decision that is favorable to policyholders. The reason that the court found in favor of policyholders in connection with its claim for coverage under a property insurance policy for COVID-19 loss was based on how the policyholder pleaded their claim for coverage in their complaint. They alleged that COVID-19 did in fact cause direct physical damage or directly altered physical property. However, courts locally in the DC, Maryland, and Virginia jurisdictions have all issued decisions on whether or not property insurance provides coverage for COVID-19 related losses, and they are all at this point rejecting the rationale that has been adopted by the California courts, and they are finding that COVID-19 doesn't actually physically alter property, so there's no coverage under the property insurance policies. But one of the other things that we are seeing is that in certain circumstances, courts are denying coverage because there is what we call a virus exclusion in the policy. And in fact, in that first slide that I had up where I gave you the numbers of how many claims to date courts have rejected, a large majority of those claims involved property insurance policies with this virus exclusion. It basically says presence of a virus that alters property or causes a business to incur a loss is not covered under the property insurance policy.
We just have a couple questions,
Oh, sure.
but once you're finished.
Okay. So one of the things that we recommend our clients do if they are looking to pursue coverage for COVID-19 related losses under their property insurance policy is first to follow notice and proof of loss requirements. For many of your companies, this would mean that you needed to give notice to your insurance company as soon as you were aware that your company was experiencing a loss under the that could potentially be covered under the property insurance policy. If you have provided notice to your insurance company and they have denied coverage, another thing that we commonly see in property insurance policies are contractual limitations provisions that limits your ability to sue the insurance company after they deny coverage to a specified period of time. Sometimes it's as little as 1 year. In contrast, most states have a contractual limitation or a statute of limitations that limits your ability to sue a party that's breached their contract to, sometimes it's 3 years, sometimes it's 6 years, sometimes it's 10 years in the state that you're litigating against. But if you are dealing with an insurance policy that contains this contractual limitation provision, one of the things that we suggest doing is just reaching out to the insurance company and asking them to extend that limitations period. Also, consider engaging counsel to prepare a tolling agreement for you. That's going to extend the time that you have to sue your insurance company for wrongfully denying a claim. Also, when you are going through the policy renewal process, consider making sure that you request different coverage grants that have been found to respond to COVID-19 related losses and other pandemic-related losses. One of the key coverage grants that we have seen is what's called communicable disease coverage. So that's going to be triggered anytime there's some type of disease that results in business interruption loss to your company. We found that in most cases where there is communicable disease coverage available, these are actually the cases that are surviving insurers' attempts to disclaim coverage.
You can just review the next 4 slides.
Sure. Okay, so moving on, some practical tips for preserving and maximizing coverage, and these are going to apply across the board to all insurance that you have, whether it be liability insurance or first-party insurance. The first being, if you have experienced a loss or a claim, provide notice under any insurance policy that's potentially impacted by that claim. We recommend that you have some type of system in place that allows you to quickly identify the insurance policies that you have available, and then you'll want to assess whether or not those policies would actually provide coverage in the event of a claim, and give notice to your insurance company as soon as possible, because one of the primary ways that insurance companies get out of providing coverage to you is by alleging that you have provided notice too late. The second tip would be making, I mentioned that one, sorry. The second would be if you have allegations in an underlying complaint that potentially fall within coverage, your insurance company is going to be obligated to defend. So that point that I made earlier, don't take your insurance company's no for an answer. You really want to harp on that, because an insurance company, particularly in the context of a liability insurance policy, has a broad, very broad duty to defend any claim that is even potentially or tangentially covered under their insurance policy. If the insurance company defends under a reservation of rights, the law in many jurisdictions is going to require the insurance company to relinquish control over the defense. So if you are dealing with a liability insurance policy, the insurance company has a defense obligation. They can defend you in one of 2 ways. They can just give a blanket defense, which means that typically they are going to control the defense. They are going to control a lot of the decisions that are made in connection with the defense. Or they can agree to defend you under a reservation of rights, which means they are pointing to different policy provisions that they think might bar your ability to actually get coverage under their policy, and they are reserving their right to raise those coverage provisions as a defense to coverage against you in the future. In the event that that controls, it creates a conflict of interest between you and the insurance company, which allows you to retain your own counsel but have the insurance company pay for it. Insurance companies may try to impose litigation guidelines on defense counsel. These litigation guidelines are often not even contemplated by the insurance policy. You don't actually have any obligation to comply with them outside just it being easier to get your bills paid if the insurance company is demanding it. But sometimes they'll make guidelines limiting the amount of money that your defense counsel can charge in connection with the claim. They'll limit the amount of time that counsel can spend researching issues related to your claim. They'll limit the amount of lawyers that can work on a particular claim. Some of these might actually be
Thank you
harmful.
so much. I'm sorry. It's just we have some people that we have to, and we have to kind of like get to this classroom before they leave, and they're on a time frame. So I need to ask these questions. I'm so
Completely
sorry.
understood.
I have to ask these questions before the kids are done with their things. So I'm sorry for that. Okay, so hello Candace Duggar and hello Candace's classroom. We have a group of young entrepreneurs who are watching this, and they're learning a lot. So thank you for all of this amazing information. But these young guys, ages 8 to 18, have questions about some of the LLC incorporated type of stuff. But the basic question, and this is just what I have here, we have young entrepreneurs under the age of 18 who are creating six-figure incomes in sales and business. What steps should younger entrepreneurs take to get started, as far as, are they under the same legal contractual things as over 18?
That's a good question. I mean, generally speaking, contractually, if you're not 18, many jurisdictions won't recognize your ability to contract, or they will give you the right to rescind the contract up until the point that you turn 18. So it's going to be jurisdiction specific, but certainly just like any business, I think you would take the steps that we're discussing today. You know, you want to figure out what your business model is going to be, whether or not you want to set up as an LLC or a corporation. You certainly, if you're generating those levels of income, if you're considering having employees, you want to think about the issues that Russell raised. And then just like any business, of course, you want to protect your business, your profits, your equipment. There's all sorts of potential coverage issues. And so, you know, really the issues we discussed today are all things that they should be considering. I don't know, Russell, anything to add?
Yeah, I'd just say it's certainly, you know, when you're under 18, can you form an entity? I mean, that's the first question, is how to navigate that. And then once you're a business, just like you were saying. But I think figuring out kind of how to set up your entity if you're under 18, the best way to do that is got to be the starting point. And it's frankly a little more complicated, just because, you know, in a lot of jurisdictions you can't form a contract if you're under 18.
Oh, that's a great question then. So you can't form a contract if you're under the age of 18 in certain districts?
Yeah, you typically need a cosigner because you're not of the age of majority, and you therefore lack the mental capacity. So just something to consider. So to Russell's point, you got to figure out how you're going to do that and who potentially is going to act on your behalf. No.
Okay, moms and dads, momagers. So yeah, we have one guy in our collective who is watching, and I think his dad is Ryan Findley, but he is actually the employee of his son now, who is making six figures in sales. So I think his son is 10.
I hope he's a good employer.
Well, he needed a driver, so his father's the driver. So thank you for answering that. And then I think we have another question. Let me see, do you want to read that?
Sure. There was a question, can you include and enforce a contract clause allowing photography of a finished project? Sure. Again, you just need to make sure that you draft it. And the question that I would say that you should consider, or the issue you consider, is how do you enforce it? I mean, you can go to court and give the ruling from the court saying, yes, you have to let me take a photograph of the finished project, but you know that's going to cost time and money. So you want to think about that. Maybe have a clause in there or some sort of provision that would compensate you if you had to go enforce that. But sure, you can, as long as the contract provision is not unlawful or unconscionable, generally they can be enforced. And then I had another question. I'm listed with my spouse on the LLC registration, but not on the business registration with the state. Am I considered a legal co-owner, or is this something I should do? I'm not sure I understand the question. I think the question is what do I need to do to be identified as a co-owner of LLC? LLCs are a little bit different. Because there isn't technically an owner. You're either a managing member or a member, and you define in your corporate documents what your rights and duties are. So what I would say is, I don't know what your corporate documents say, but it would be worth, again, not going online and creating something. Again, they're not that expensive to generate, but to explain what your business goals are, what the purpose of your business is, and what you want you and your wife, as assuming you want to be a co-owner with your wife, what you want your rights and ability, rights and powers to be under that operating agreement, and have them spelled out that way.
Thank you.
Yep.
Okay, so David, do we have any other questions from the live stream?
No, I think that's it. We
Okay.
can just go back one slide so she can talk about the concrete.
Does anybody here have a question? Anybody have a question? Okay, David? Here?
Hi, this question is for Mark, and my question is this. So cash flow is obviously critical to small businesses, and so with respect to delayed payments or thinking about offering credit terms of net 30, net 60 to a client, how does that tie into the concept of pay for payment? What is the legality of that? And is that going to change anytime soon? And how do I protect myself from potential litigation from the subcontractor? So pay for payment, meaning paying the subcontractors once the contractor is fully paid on a project.
Okay, I think your question deals with how do you organize, or how would you draft payment clauses to make sure that you're not required to pay until you're paid?
Right.
Right, and there is some change coming up in Virginia law on that. Some's already been passed as of July. I think there may be some other amendments coming up later. But there, a provision that many contractors have seen is from an owner is a paid when paid, right? So the contractor will say to the sub, I will pay you when I'm paid and if I'm paid. Under certain circumstances, those provisions are going to be unenforceable in the future. So what I would say is going forward, just make sure you have very detailed payment clauses in your construction contracts with your subs and with the owner, typically, because everybody wants to get paid, and if they're not getting paid, what's the remedy, right? They stop work, and they shut down the project, and then we've got a lot of problems. So it's really important to negotiate and make sure the subcontractors understand those payment provisions. Areas where they can get a little bit tricky is when you have payment clauses that require certain documentation that you need to submit, and you have a project representative who maybe is slow in reviewing or approving or is nitpicking. So, that's one of those things that you just need to make sure you have a well-drafted contract and that you understand the consequences of some of these payment provisions that come out. They're smaller projects, it's probably not so much an issue, but you get larger commercial projects with more larger, sophisticated, they tend to get these super long, right? You have the standard form agreement, and then you have the general conditions, you have supplemental conditions, and at the end of it, you've got 100 plus pages of contract documents that no one can understand. So I would just make sure that that is very clearly explained, not only to your satisfaction with the owner, but also with your subs.
Great answer. Mr. Cassidy.
Okay, well, first of all, thank you to everybody for some incredible information. From the standpoint of the social collective, I know when we do coffees, Lisa normally throws out some questions. How many people have been in business for over 20 years? And maybe one or two people, raise your hand. How many people have been in business under 5 and then under 2? It's surprising how many people have just started their business. So I'm wondering, would it make sense just to develop a simple checklist for new people starting a business of some of the key things they really need to consider?
Just like
Amen.
like a welcome package.
Well, just take,
I would pay for that.
It's just a simple checklist for starting your business, what type of entity should it be, a C corporation or an LLC? What should I consider from an insurance standpoint? It's something that will create questions in your mind, so they contact professionals.
Right.
Find out for sure what they really need.
So I'm sure you guys have something like that where it's just a basic sheet that when you first start your business, I mean, you're right. Good point, Pat. We have so many new 5-year and under businesses in the collective and probably everywhere. It's representative. Is there something like, I know when you buy a house, you get a welcome to the neighborhood thing. Do you guys have something similar to that?
I don't, unfortunately, and I have not thought about it. Russell,
Well,
have you?
I think it's more practice specific from it instead of
Yeah,
being
well-
globally, because there's different components. You've got the contracting, the employment, the labor.
The challenge
insurance.
ultimately, I think what we have, and we can easily put together, is these are the questions that you should be asking, but then it's like a choose your own adventure. As you start answering those, then there's, okay, well, do this, do that, put this agreement in place, but edit this part out. And it ends up becoming very customized and individual. The questions, here are the things you ought to be thinking about, I think is a universal, especially for smaller businesses just getting started. But then it becomes a very customized, bespoke approach after that.
Thank you, Pat. I was thinking the same thing, so thank you for that answer. Now I understand. So does anyone else have any questions while we have this amazing panel here? Anybody? Alina.
So this is not really a question, but when we had talked the other day, you had said something about having a lawyer on retainer for contracts and something like that. And we talked about, well, most business owners are terrified they can't afford that, or
Right.
that it could be out of reach. So could you talk a little bit about that?
Yeah, one thing that you could do
because a lot of times you have these questions, right? And what do? We have a question, we go to Google. And then we scare ourselves to death, right? Because we find out that we have cancer and we're going to get sued. So, right. So, but absolutely, something that we've all done certainly, and we're delighted to do is to fill out a small retainer and just be on call. And it's up to you, right? The money's there. You put down your deposit of a few $1,000s, and then you have a business lawyer on call. And the benefit of that is one of the things lawyers have to be mindful of is conflicts. Okay, so if you want to lock up a firm and make sure that they're not being adverse to you, that's potentially one way to do it. But two, when you have a problem, right, you need someone that you can get contact right now. You don't have to go up there and set up the relationship. The relationship's there. They're going to have some understanding of your business, and then you can give a call or an email and say, hey, I have an urgent business question I'd like to talk to you about. And a lot of times that business question can be resolved in 15 minutes, which is not that expensive. And if 15 minutes prevents you from making a $15,000 mistake, it's in my opinion, it's a good return on your investment. And especially employment's a classic one, right? You're having that difficult, you're yes, you're about to break up with this person, or maybe worse yet, they've done something that's really made you upset, right? And think before you speak, make that phone call. And make sure that you think through what you're going to do, and that before you take that step, that you're not setting yourself up for exposure. We're minimizing that exposure.
So I'll just say that really quickly, and then I'll wrap it up because I know I have to respect everybody's time. But in the plumbing industry, we have clients that we've had for 20 years now, and we have a relationship with them based on history. So if you need us and we're booked, we're probably going to prioritize you because we have a relationship with you. Similarly, when you're on retainer, you may not have 20 years of history, but you are now in a relationship. So you will be prioritized, I'm sure. I highly recommend that as a family member of a few attorneys. I can tell you that you want somebody to be on your retainer. You want to put a good law firm on retainer because you are, as a business owner, going to have these questions. They are time sensitive, and you want to be a priority with a really great law firm. So, Offit Kurman, obviously you guys are amazing. So thank you so much for this. Does anybody have anything else that they would like to add?
Thank you for everyone's time today. Thank you for coming and joining us.
Yeah. Oh, I would like to also thank our sponsors. Okay, so thank you to Tina with McCabe's Printing. Thank you, Tina, for creating all of the print and banners. Thank you to me for being Artisan Plumbing. Thank you to D. Hill, your partner for life, D. Hill Financial and Insurance Broker, the best. He's my guy. Jeff in High Def in the back, who is a 3-time Emmy Award-winning producer. And I just love our team and how everybody volunteered. Offit Kurman is on our team. Everybody coming together to support small businesses. And it's just a beautiful thing to see. So, and then we have, is that it?
Next slide.
Oh, we're doing a slide? Okay. Okay, and then thank you, Mark Shaffer, Russell Berger, and Courtney Alvarez. Thank you to Offit Kurman. Thanks for being here, guys.